Hi, in this video I want to talk about the issue of workplace privacy and the employee's use of the computer facilities of the employer. So first of all, under Ontario law, there's a statute requiring the employer to advise all employees as to what techniques it is using to monitor employees in the workplace for security purposes involving use of the company's workplace computer facilities. That applies only where there's 25 employees or more. BC and Alberta has similar legislation, and it must notify the employee before it attempts to collect any information. The federal government has similar legislation requiring the consent of the employee before any information is gathered. And Quebec law, which is probably the most progressive, requires there to be a serious issue before the employer can take such steps to collect any personal information from their monitoring techniques. So those are the statutes. That being said, the common law cases have added more protections to the individual. These arise in criminal cases most often, but the criminal cases talk about important principles that will apply to normal employer working relationships. The most prominent case, the early most prominent case, was a case called Regina versus Cole. And Cole was a high school teacher who regrettably had stored images of nude students on his computer. In any event, not particularly tasteful conduct, but what happened in that case is the employer had a policy document which allowed it to mandate what could and couldn't be used with its computer facilities, such as dealing with personal information and the like. And the Supreme Court said, well, that doesn't necessarily rule the day, that an employee may have a reasonable expectation of privacy with respect to information that he or she stores on the company computer facility. So just because there is a document giving the employer that right, that does not necessarily rule the day. That you must consider, the courts must consider what is referred to as the biographical core of the individual's personal information. So if, for example, using that as an analogy, that there's information stored of banking information or personal logs of a diary detailing issues in the individual's life or relationships, that information cannot be accessed by the employer. There's also cases dealing with text messages and emails, also in a criminal context, but basically ending up at the same point, that you have to consider what is the reasonable expectation of privacy of an individual, notwithstanding an overall document that the employer has in its argument. The most recent decision that went to the Supreme Court of Canada involved two teachers, and they kept a Google log that was protected by password. And basically, they used the Google log to exchange information about the school's policies, the principal's conduct, and allegedly preferring other teachers, blah, 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 stuff like that. And the one teacher left her computer open on her desktop, and the principal or some other school official came in and noticed it and proceeded to take not screenshots but iPhone shots of each page of the log, and that became the controversial issue. Ultimately, the Supreme Court upheld the Court of Appeal decision, which said, hey, come on, we got to understand what's going on here. Look at it. Look at the situation. Clearly, there was an intent to keep this information private by virtue of it being password protected, and it dealt with confidential communications between the two parties. So just because the person happened to leave it open on her desk one day does not give unfettered right of access to the information. So that was under a charter argument, because schools are, without getting into all the intricacies of charter arguments, are public bodies. But it's still, the principle should still apply to every common law employment relationship, that just because there is a constitutional document that the employer created, giving it an apparent right to access the documents on its computer software and hardware, does not mean it's valid. All this being said, take this as a note. Every employee would be insane to use the company's computer systems to record anything that's even close to a private nature. There's just no reason for it. And you're exposing yourself to all kinds of future problems. So don't do it. If you're going, and don't even use a third-party server like Gmail or Hotmail, because the company can follow you into those things because you have to tap in your password. And same thing for text messaging on phones. Don't do it. And with respect to social media, be sure your social media settings are set to private. On Facebook, WhatsApp is encrypted and it's clearly intended to be private, but make sure all your settings are noted as private. There's all kinds of cases in which information on social media has been used to hang the employee, terminate for cause, where it revealed something insidious that's conduct of the employee that's detrimental to the employer's interests. So be extremely careful what you post on social media. It's all admissible against you. Be extremely careful that your social media settings are set to private, and never ever use the company's computer system in any respect for personal information.